Hello, everyone. My name is Devlin Hartline, and I'm legal fellow at the Hudson Institute's Forum for Intellectual Property in Washington, D.C. We have a wonderful panel for you today on an issue that is near and dear to my heart: how to make copyright protection meaningful for everyone. After all, chances are that every single one of us is a copyright owner, whether we know it or not. And while it's true, at least in theory, that we all have copyright rights, the reality on the ground has been that it's not practical to enforce those rights. Copyright cases have always fallen under the exclusive jurisdiction of the federal district courts, and litigation in federal court can be very timely and expensive. Everyday copyright owners have not been without some recourse. For example, if someone's work is infringed online, that copyright owner could send a takedown notice to the service provider to have the infringing material removed. But experience tells us that this process doesn't always work as well as it could. And moreover, merely taking down the infringing material does not compensate the copyright owner for the wrong that has been committed against them. In order to make it easier for everyday copyright owners to enforce their rights, Congress recently established the Copyright Claims Board, or the CCB, within the US Copyright Office. It hears certain low-value copyright claims. It's basically a small claims court for copyright. And after many months of hard work by the US Copyright Office, the CCB finally commenced operations on June 16th. We have with us today three panelists who are experts on the CCB. We have Maya Burchett, attorney advisor at the Copyright Claims Board, US Copyright Office; Terica Carrington, who is vice president, legal policy and copyright counsel at the Copyright Alliance; and we have Michael Clipper, who is partner at the law office of Michael R. Clipper. I am thrilled to have this team here to discuss the CCB. We'll start with short introductory remarks, and then we'll get into a discussion about what the CCB is, how it came into being, why the CCB is needed, and finally, how it works in practice. And with that, I'll turn it over to the panelists for introductory remarks, and we'll start with Maya.
Hi. So as Devlin mentioned, my name is Maya Burchett. I work here at the Copyright Office. I've been at the Copyright Office for almost 4 years now, and been with the CCB team since October. My interest in the CCB started long before I got to the office. I remember watching the bill move through Congress while I was still at a small firm, and just kind of thinking that it would really be a really great thing for small creators and users of copyright. Happy to be here.
Great, we're so happy you're here, Maya. Next, let's hear from Terica.
Hi, everyone. So as Devlin mentioned, my name is Terica Carrington, and I'm VP of Legal Policy and Copyright Counsel at the Copyright Alliance. The Copyright Alliance is a nonprofit, nonpartisan organization that represents the copyright interests of both individual creators as well as organizations and companies. And our role in the CCB and before the CASE Act was that we advocated for the CASE Act for many years on behalf of the copyright community, and in particular, individual creators who are most at need for a tribunal like the CCB. And our advocacy efforts played a significant role in getting the CASE Act passed. So I'm really excited that the CCB is now up and running, and really excited to be here today to talk about it.
Excellent, thanks, Terica. And finally, let's turn it to Mike.
My name is Mike Clipper. I joined the staff of the Senate Judiciary Committee in September of 1975 as counsel to one of the Republican senators. The committee was a month away from voting on the 1976 Copyright Revision Act. Beginning with that time, I've been involved in myriad copyright issues ever since then, very often, as was the case with the CASE Act, in the copyright legislative context in Congress. Most recently, on behalf of my client, the American Society of Media Photographers, I was intimately involved in the several-year, multi-year effort to pass the CASE Act. One of my highlights of working on that Act over the years was working with so many dedicated folks who were committed to ensuring that small copyright owners and small businesses were not outliers in the copyright system. Particularly, I enjoyed working with Terica and my old friend and her boss, Keith Cooperschmidt of the Copyright Alliance. But there are many others, too many to name, who contributed to it. And in a moment, I'll be talking about a little bit about the role of the Copyright Office itself. Thank you.
All right, thanks for those remarks, everybody. It's amazing how much depth of knowledge all three of you bring to this topic, and it was like a dream team when I put this together to get all of you. And so I would like to just start with explaining to people just kind of a high level, broad overview of what is the CCB, and Mike mentioned the CASE Act, right? And so what is the CASE Act? What is the CCB? And I was going to turn it over to Terica, if you could just give us a broad overview.
Yeah, sure. So I'll start by just explaining that the CCB stands for the Copyright Claims Board, and the CASE Act stands for the Copyright Alternative and Small Claims Enforcement Act, and that's the legislation that actually created the CCB. So just to give a kind of broad overview of what the CCB is, it's a voluntary, streamlined, and affordable alternative to federal court for certain small copyright claims. And so I'll kind of break down some of the key components of the CCB. So number one is that it's voluntary. And by that, I mean it's optional both for the claimant and the respondent. So a claimant is similar to a plaintiff in federal court. And the claimant can decide whether or not they want to bring their claim to the CCB, or they can still decide to bring that claim to federal court. And on the flip side, the respondent is similar to a defendant in federal court, and the process is also voluntary for them as well. In addition, the CCB process is streamlined. It's designed to be simplified and streamlined as compared to federal court, which also means that parties are able to represent themselves. So they don't have to hire an attorney if they don't want to. They can proceed by themselves and represent themselves before the CCB. Another key component is that it's affordable. I think Devlin touched on earlier, one of the reasons why the CCB exists is to create an affordable alternative to federal court. And as I mentioned a second ago, parties can represent themselves, which creates a major cost savings because there's no need to hire an attorney, which takes up a significant portion of the expense associated with federal court. So in addition to representing themselves, they can also get pro bono representation from law students, which is sort of like a happy medium for parties that don't feel entirely comfortable representing themselves, but don't want to pay for the expense of an attorney. And then in addition, it's limited just to small copyright claims. And when I say small claims, I mean the damages available at the CCB are significantly less than what's available in federal court. So in federal court, statutory damages for copyright infringement can be up to $150,000 per work infringed. In contrast, statutory damages at the CCB are limited to $15,000 per work infringed. And there's a maximum damage award for a single case at the CCB of $30,000, and compare that to federal court where there's no overall limit in damages that can be awarded. Additionally, the CCB is limited to certain kinds of copyright claims, so not all copyright claims that are available under the Copyright Act can be litigated before the CCB. And there are three types of claims that can be brought to the CCB. Those three claims are number one, infringement claims. So that's basically a copyright owner who believes that someone else has infringed the rights that are afforded to them under the Copyright Act. They can bring that infringement claim to the CCB. The second kind of claim is a declaration of non-infringement, and that's a claim that would be brought by a user of a copyrighted work who has been accused of infringement by the copyright owner. Perhaps that person, the copyright owner, has maybe threatened to sue them or something of that nature. The user of the work can bring a case for what's called a declaration of non-infringement, which essentially asks the CCB to declare that their use of the work is not infringing. And the third kind of claim that can be brought is a claim available under the DMCA, which is the Digital Millennium Copyright Act. So Section 512F makes a type of claim called a misrepresentation claim. And so that deals with takedown notices that are sent under Section 512 of the DMCA, as well as counter notices. So if you send a takedown notice The recipient of that notice may bring a 512F claim if they believe that you've misrepresented something that you've said in that takedown notice. So maybe you misrepresented that there was an infringement taking place. And on the flip side, if someone receives a counter notice and they believe that the sender of the counter notice misrepresented something in that counter notice, they can also bring a 512F claim. And then finally, the last thing that I'll highlight about the CCB is that the process is totally virtual, totally remote. There's no reason to actually have to travel. So, in federal court, someone has to actually appear in court to litigate the claims. The CCB, although it's housed in the U.S. Copyright Office, which is located in Washington, D.C., there's never, a reason to travel to D.C. Documents and forms are all submitted online, and any hearings and conferences that take place are held virtually.
Yeah, thanks, Terica. That's great. And so, I think what's the title of this thing? It's what does the CCB mean for creators? And I think what you just said is really important about it being both sides of the creator. So if you have somebody that creates a copyrighted work, they're the creator, obviously. If somebody just, makes a whole copy of it, without any other context, that's just infringement. But I think what we're going to see a lot of is where somebody else incorporates a copyrighted work into their work, and then you've got a question of fair use. And so if they're threatened, I guess, if that other type of creator, the one that incorporates the pre-existing work, is threatened, then they can go to the CCB too and get this, what you said, a declaration of non-infringement, which is great. So it's creators of, people who have made works that have just been ripped off wholesale, but then it's also creators who incorporate other people's works and there's some kind of a dispute between the two parties. And the misrepresentation thing is really interesting too. And I'm curious to see what kind of cases we get on that for a lot of reasons, right? But yeah, so I mentioned in the beginning that, one thing you can do that's not going to court if you're a copyright owner is you can send a takedown notice under the DMCA. But those takedown notices, they have requirements, and one is that, it's got to be in good faith, right? And so if you send one in bad faith, well, you can be on the hook for that because, you're taking down work wrongly, and so you're harming the other party. But then bad faith can go the other way too. The recipient of the takedown notice can, in bad faith, say something that's not true, right? And so, yeah, it's really interesting how it balances creators on both sides. It's not just like copyright owners going after infringers. I think we're going to get a lot of closer cases, especially in the context of fair use. So anyway, thanks for that overview. And so I want to turn now to more of the historical thing. So Mike, you mentioned that you got into copyright law right before the 1976 Copyright Act, which if people don't know, that was the latest huge revision of copyright law. And in fact, the 1976 Act is still law today. It's been amended a lot, but that's the copyright law that we have today. And so Mike was there, which is amazing, and he's here with us today. And so, Mike, what can you tell us about what's the history of the Case Act, the thing that created the CCB?
First of all, I feel compelled to say I was very young and just a few years out of law school when I joined Senator Mathias' staff on the Senate Judiciary Committee. I had not taken any copyright. I'm not sure it was offered at my law school, something that luckily has been corrected virtually in every school I'm aware of today. But it was the day after Labor Day I started, and a month later to the day, the committee marked up S22. And that was it. And so that gives me, I guess, some credentials to talk about history and what's happened in the interim 47 years. I think what's important, the real question for us today is, how did the CCB come into being, and why were so many devoted individuals and small businesses that have such limited resources work and so little experience in the congressional legislative process? Why did they, for really the first time, pursue a piece of legislation upon which they were among the key beneficiaries, or thought to be? think that's sort of what we're talking about here. I think the answer is straightforward. It was designed to correct a historical inequity in the copyright law, and where many copyright owners, individual creators, small businesses, to note them again, felt like, to use the word again, outliers in the copyright system. I think that's what got this started. Interestingly, I was reviewing a law review article this morning, which reminded me that all of this began as a practical matter in 2005 during hearings on orphan works, where one of the photographer organizations, one of the sister organization to ASMP, suggested that Congress needed to look at this whole issue of small claims. Subsequently, it began. But before I get into that particular history, I want to talk a little bit, and I hope I'm not going to take away from further questions. The fact that how important copyright is, not just to all copyright owners, but let's focus upon the type you alluded to in your opening statement, Devlin, and that is the small creator and small business who are really dependent for their livelihood on the proper operation of the copyright law, and that includes in particular the access to the courts and remedies. Again, as Devlin mentioned, prior to the Case Act, I can say that now, federal courts were the exclusive remedy for copyright infringement. And that often proved too prohibitive and too complex, as it has already been alluded to many, many creators and small businesses, including members of my client. All too often in the past, and this is a problem which has only been exacerbated by the digital revolution, where it is so easy to make copies and transmit them worldwide, perfect copies. I will tell you as an aside, when I was working with the Motion Picture Association many years ago, our main goal was to go after what we call back-to-back copying. Hundreds of video VCRs lined up together where each additional copy deteriorated. That's not the case now. So just think about the threat of what the digital technology does to the security of your work, and then focus within that subset upon the type of people who are seeking to change the law in the Case Act. One small business owner at a hearing that I think Terica, Devlin, and I attended in the House about 4 years ago, addressed a question that I think is very important and was addressed repeatedly during the hearings and the process on the Case Act. And that is the question of registration and why the type of copyright owners I'm talking about have such low registration rates. It's because the registration, the incentives are really are litigation based. And there's this incentive, why pay the money as a small business person or individual to register a work if ultimately the benefits of that registration, to me, are illusory in too many instances. So what happens? 2005, there's a hearing, and then 5 years later, the then chairman of the House Judiciary Committee writes a letter to the Copyright Office and suggests that they conduct a study on small claims. The Copyright Office then issued a report in 2013, which quite frankly became the real impetus and the basis for the legislation before us. The office deserves great credit, not just for that document, but playing a critical role throughout the legislative process and its yeoman efforts. I'm looking at Maya now. Its yeoman efforts in taking what was enacted in December of 2020 into a series of regulations, handbooks, et cetera. And I think we're all waiting eagerly to see how this unfolds, in the coming months. And I think we really are indebted to the office for what it did. I think they listened to the commenters during the process, and they did a firsthand job, in responding to them. And where questions remain, they've indicated that they will talk and act accordingly in the future if there's appropriate need for change.
So Mike, let me ask you, was it really like, small businesses and artists who were pushing for the Case Act and not so much the Disneys and the Motion Picture Association, and it was kind of more of a grassroots effort?
For me, it was primarily the individual businesses, individual creators and the small businesses. I mean, Tara can address, with given her membership being more diverse than my clients, I think she can address it. But make no mistake about it, as I said earlier, I do not recall, and some of my friends may correct me, most of them who have retired and probably won't see this. It really was an effort by a small group of people who had a good story to tell. They had good spin, but were truly unexperienced. And I would, in addition to praising the Copyright Office, the Copyright Alliance, other groups like the authors, songwriters, et cetera, deserve great credit as well. But I think that Terica may want to jump in at that point, but we'll come back to it later. I think it was driven by the smaller creator. It really was their effort.
Yeah, well, I mean, and that makes sense, right? Because, the Disneys of the world are going to go to federal court. They can afford it, right? You've got a small claims court for regular everyday people. So it makes sense that they, came together to push for this. And so who was pushing back on it? I mean,
I'll get to that in a minute, because they didn't,
okay.
They didn't emerge at the beginning, but let me get to that in this. I'll get to the legislative debate in a second. And I'm sure my friend Terica, who sat through how many meetings with me, Terica, over several years?
Countless. I couldn't even guess.
Can't begin to count them. Can't begin. But one thing I wanted to mention before we get into that, and I think this is important, and I don't think I'm wrong, it's certainly rare, if not unprecedented. The Copyright Office did something that you don't normally see, and it appended to the report, its long report, draft legislation on the small claims. Not something, and Maya may want to correct me, that is typically done, but on the many issues I've worked on, I'm straining to think of one where that was done, certainly with the thoroughness that was done. What's fascinating about that draft is that while Congress amended the bill many times, in many places, and made additions in response to concerns raised during the legislative process, the thrust of the bill was unchanged, and the bill was faithful to the detailed analysis of the law, the constitutionality, et cetera. But it is remarkable to juxtapose the bill versus, the report, the one reported by Congress and signed by President Trump. Doesn't mean there wasn't a lively debate. It doesn't mean that there weren't groups who have typically been critical, of copyright didn't join it. It didn't mean that there weren't members of Congress, although there were few of them who opposed it, or at least questioned it. But it made for a very lively debate. But I think the Copyright Office's credit is much deserved in that report.
I remember a certain senator putting a hold on it.
I can't remember his name. Somebody from Ron from Oregon.
From Oregon, yeah.
Ron Wyden from Oregon. But
right.
in the end, it was enacted. What I want to say is, and it goes to your point, the people who push this legislation, I'm only going to name a couple of them: Hakeem Jeffries in the House from New York, Judy Chu in California, Senator Kennedy from the state of Louisiana, and of course, Dick Durbin, and you may want to throw in a couple more, from Illinois, now chairman of the committee, all did great work. And one thing they did is they listened, and they made changes that were both driven by, concerns that they understood, and in some cases by political considerations. And I'll just mention a couple to begin with. There was a provision added in the bad faith context. They extended some of the protections that we had in the original legislation to that. They talked about the library and archives were able to get a provision on how they could remove themselves from the CCB process, which I'm sure that Maya, will at least allude to if I finish. and I think there was that process, and it was basically over 2 Congresses that this evolved, and we were in discussions with the critics of the legislation throughout. The House held a series of meetings, that they brought together people from both sides to have the debate, and we had it. So it was very well vetted. I was reading an article the other day that said one thing you can't say about it is that there wasn't a lot of talk about it in consideration by Congress, because it really was. And
well, it's funny you say that, because I've heard people say that they snuck this thing in and nobody ever talked about it. And I was like, they talked about it for like 15 years.
The piece I'm alluding to said, this is what they said, and said wrong. It simply wasn't true.
Yeah.
And I think that's very important to maintain. But ultimately, due to the efforts of those members, it was enacted. And then it became Maya's job and her colleagues at the Copyright Office to take it. And that's where we are now. I hope that's enough of a historical.
Yeah, no, that's great. And like, I remember towards the end of 2020, and I was thinking, this thing, it's not going anywhere. They're going to have to reintroduce it next year. And, it's just going to go on forever. We're never going to get it. And then all of a sudden at the end of the year, they attached it to that appropriations bill, and it went through. And then like President Trump signed it like a couple days later, and I was like, "Whoa, we just got the CASE Act! Like that just happened." It was a crazy time.
We were not sure how it would turn out. I think it's a fair assessment. It was the final thing I want to say is to echo something that you picked up on from what Terica said, and what Congress came up with a fair, balanced bill. And that's protective, I think, of the interests of both the claimants and the respondents. And I think that's a message that people have to get out, because that was a lot of what was going on, during the changes that were being made in the debate. And it should not be seen as someone's tried to characterize it, as a one-way street, because it's not. It's a fair.
Oh, exactly. The respondent could very well also be a creator, right? Like, so that's what I'm saying. I think a lot of these cases are going to be fair use cases, and there's creators on both sides. Yeah. All right. Thanks, Mike. That's great. So we have the CASE Act. And so my next question is, who in the heck is actually going to use this thing, and who is it going to benefit? Why is it needed, and why is it voluntary? And so, Terica, if I could put you on the spot.
Yeah, sure. So, the question of why it's needed, I think a couple of people have touched on it already, but I'll just reiterate and kind of add a little bit more context to it. Federal court is really expensive. The average cost of litigating a copyright infringement case from start to finish in federal court can be upwards of $500,000. And so your average individual creator or small business really just doesn't have access to those kinds of funds. And so the CCB was created in order to be an accessible forum for certain copyright claims. And that's of benefit not only to creators, but also to users of copyrighted works, because just as it's expensive to litigate as a plaintiff in federal court, it's also expensive to defend a case in federal court, or it's also expensive to bring a declaration of non-infringement in federal court. And so, of course, it's going to benefit individual creators who haven't been able to afford litigation in federal court. But I also think it's worth highlighting that there are some individuals and businesses that can afford federal court today that will still use the CCB instead where appropriate, because there's such a significant cost savings, and because the proceeding is so streamlined and simplified that it's just much more easy to use and much more beneficial from just a cost perspective. And then also it's beneficial for users of copyrighted works as well. As I mentioned, they also have not had an affordable forum to have their claims heard or to defend claims. And then in addition, there's significantly limited liability in the CCB as compared to federal court. So I mentioned before, statutory damages in federal court can be up to $150,000 per work. We're here in the CCB, where statutory damages are limited to $15,000. Well, that's 10% of the maximum that's available in federal court. And so that's another, benefit, as well as a reason why, respondents would choose to participate in a CCB claim. Because again, as I mentioned, it is voluntary. And so you also asked, why would people use it? So again, that's one of the reasons. Limited liability. In addition, the significant cost savings, there's no need to hire an attorney. And that represents a significant part of why federal court is so expensive. So the ability to not have to take on that bill reduces the cost significantly. And then the fee to actually file a case at the CCB is hundreds of dollars less than the fee for filing a case in federal court. Additionally, ease of use, it's designed to be simplified and streamlined. So people are going to want to use this because they don't have to hire an attorney. They can represent themselves and they can actually understand what it is that they're doing without having to, need to rely on legal expertise. And then speaking of expertise, something that's also unique and I think of benefit to both creators and users, users of copyrighted works, is that the CCB judges, who are referred to as CCB officers, Copyright Claims Board officers, are actually copyright experts. So they have significant experience in copyright in various representing creators of works, representing users of works, and then also having experience in alternative dispute resolution. And so, that's a benefit because in federal court, judges who hear a copyright case may have never had significant exposure to copyright or may not understand some of the nuances related to certain kinds of claims, whereas these CCB officers are going to have a lot of familiarity and expertise on how copyright works and how to apply the law to the facts before them. And then in addition, it being virtual. So, and I think something that's interesting about that is that was a feature. So Mike talked about how, there were some changes that were made to the to the CASE Act over the years as it went through Congress. This was not one of them. It was actually designed to be virtual from the beginning. This is not like a pandemic related change to the process that was already kind of baked into the legislation from the start. And so I think the ability to have your case heard, have it heard quickly, have it be heard in an affordable manner, and not to have to travel anywhere are all going to be significant reasons why people choose to come to the CCB to bring their claims, and also why people, respondents specifically, choose to participate in a claim when they have a case brought against them. And then I think you also asked about, why is it voluntary? And that's not a surprising question at all. That's a question that I hear probably almost daily since people really started to understand and know about the CASE Act and know about the CCB and the fact that the proceeding is voluntary. And so the reason why it's voluntary, in particular for respondents, is because there's a right to have a jury trial and there's a right to have your case heard by an Article III court. So in particular, specific to what we're talking about, your copyright claims, you have a right to have a jury trial, you have a right to have those cases heard in Article III court, which is a federal court. When I say Article III court, that just means a federal court. But those rights can be waived. And so that's why the respondent still has, that's why the claimant still has the right to go to federal court instead of the CCB. And that's why the respondent can choose to opt out of the case, or they can choose to participate in the case.
Yeah, it's interesting because the benefits just aren't for the claimant, right? The benefits are for the other side too. And so it's great, I think. And the voluntariness, we're going to see, a lot of people saying, oh, it's voluntary, nobody's going to choose to do it. But I don't think that's true at all. Especially if you're a respondent and you think there's a good chance that they will sue you in federal court if you don't do the small claims court, then you probably like the small claims court better, right? To cap on damages. And go ahead.
Exactly. And I think in addition, in particular respondents who are able to look at whatever it is they're being accused of, and they realize that they have infringed someone's work. In particular, they are going to weigh out the cost benefits of going to the CCB. They're going to look at the potential liability at the CCB versus federal court. And I think in a lot of cases, it may not be worth the risk of kind of playing that game of, well, are they going to take me to federal court or are they not? When you see what you could potentially be required to pay in federal court versus at the CCB, especially when you know that you have infringed that work, even if it wasn't on purpose, like maybe some sort of oversight happened, especially maybe from like a business perspective. So I do think there are definitely going to be reasons why people choose to participate as opposed to opting out.
Yeah, and it could lead to just a settlement agreement between the parties, especially if it was like an accidental, obvious infringement. And so, I wonder, like, what does it even cost to go to federal court now? What's the filing fee? It's like $500.
So it's
file it?
roughly 400. I think it's like 402 or some like.
Oh, okay. Yeah,
great.
that's crazy, right? It's so
Yeah.
for a lot of people, that's like more than they could ever afford anyway, much less like the thousands and thousands of dollars if you hire a lawyer. And so, well, and I want to talk about, so how exactly does the CCB work? Like, let's talk about the nuts and bolts. And we have Maya, who's an attorney advisor at the CCB. So I don't think we could ask anybody better than Maya to talk about that.
Right. So I get to talk about the fun bit and try and tie some of the strings that Michael and Terica and Devlin have all mentioned into how does this thing actually work. So implementation has been a big lift for the office. The statute gave us 1 year plus 180-day exception to get the CCB up and running, which is incredibly fast for government who's used to, a bureaucratic model of like, let's wait and see and let's take our time. So the office got started immediately. And I like to think of implementation of the CASE Act that Michael and Terica talked about in 4 buckets. So first, we got all staffed up. We got the copyright claims officers that Terica mentioned. We have 3 copyright claims officers, David Carson, Monica McCabe, Brad Newberg. Their bios are on our website, which was also a lift. So you can see and read everything I'm talking about on ccb.gov. So the first thing we did is we got all staffed up. So we got our copyright claims officers, and then we also hired copyright claims attorneys, of which I am one. So we have 3 copyright claims attorneys, a paralegal, and a program specialist, giving us support in all the ways we are going to need it. The second thing we did is we got working on developing the necessary technology. So we created our own filing system. It's called eCCB, and that's where claimants are going to file their case, pay for a claim. It is where the respondents can either opt out or choose to respond to a claim, and it's where the public can follow along. All of the pieces and parts that participants will need as far as filing a claim or responding to a claim are going to be there on eCCB. We also developed the designated service agent database. Now that's for corporations to list one specific representative, one individual to receive CCB claims. So they're not getting directed somewhere where they're not, so they're not getting lost. That is also up on our website. As Michael mentioned, we handled all of the regulations. Now, while the CASE Act that was haggled over and talked about and legislated laid out a number of things that the CCB can do that they can't do, and a number of procedural hurdles, it also left a lot of things up to the discretion of the office. So we drafted a ton of regulations that really nailed down the nuts and the bolts. How much is a CCB filing fee? What does need to be included in a claim of infringement? What does someone need to give us in their claim for a declaration of non-infringement? So the regulations really nailed down all of the day-to-day nuts and bolts of how the CCB is actually going to conduct business. And then lastly, we worked with our public information office to develop a wealth of resources. As I mentioned, they're ccb.gov, and on ccb.gov, you can find our handbook, which is a step-by-step guide in filing claims, responding to claims, opting out of claims, considering whether or not to opt in or out of claims, how to use eCCB. There's a wealth of resources on that website, and more are coming. So that's our kind of 4 implementation buckets. And to kind of walk you through the initial stages of a case, well, first we use that tech we developed. So potential claimant would go on ccb.gov, peruse the website, decide the CCB is the forum that they want to pursue their dispute in, flip through the handbook, make sure that they're all set with all the materials that they need. The next thing that they would do is register for eCCB, again, which is our filing system. It's super easy. It's connected to login.gov. If you've ever used TSA PreCheck, you have a login.gov account. If you've ever used USA Jobs, you already have a login.gov account. So you're going to use your login.gov to register for eCCB, pick your user type, and then just like that, you're ready to file a claim. You're going to hit file a claim, and the claim flow will walk you through a number of questions that you'll answer about your dispute. The first thing you'll do is you'll choose one of those 3 claim types Terica talked about. You will add in your registration information that Michael kind of alluded to. Why would someone register? A difference between the CCB and federal court is that you can come to the CCB with a pending registration. So you would either enter in your pending registration number or your actual registration number and get started filing your claim. And then the claim flow directs you to add kind of a narrative about the harm you suffered and the details and facts surrounding your dispute. And after that, you're going to pay a $40 fee. And this is where I'll stop to talk about kind of the regulations and how the office has tried to be really responsive to some of the comments we received during the regulatory process about the fee. So initially we proposed a $100 filing fee. A part of that was because of the way the statute was drafted. We got a ton of comments, more on that issue than any other issue that we drafted, about the cost barrier that would create for certain copyright owners and copyright users. Because of that, we've lowered the fee. We've actually split the fee into two payments. So the first fee has been lowered. A copyright creator or a copyright user would initially pay $40 to file their claim. If your respondent decides to participate in the CCB proceeding, you'll be prompted to pay another $60 fee. If your respondent decides to opt out, that's it. You don't have to pay the additional $60, and you can choose to pursue your case in federal court. After you filed your claim, you've clicked all the way through the buttons, you've paid that initial $40, your claim will go through what's called compliance review. Now, compliance review is also to help respondents. It's to make sure that the claimant's claim states everything that is necessary, that it follows all of the Case Act rules and regulations. Compliance review is done by the copyright claims attorneys. So I will be one of the people looking through claims, making sure that it meets all of those applicable regulations. After I've given it the okay, you've stated a claim, you've clearly stated this claim, you've included all of the information we've requested, the claimant will have the claim served on the respondents. And then that's when the countdown starts. Then a respondent has 60 days to decide whether or not to opt out of the proceeding. Again, there's a wealth of resources on our website for respondents in particular to help them kind of make that decision for themselves about whether or not they want to participate. And as Terica mentioned, we think that there's a number of reasons of why respondents will ultimately choose to participate in a CCB proceeding. After a respondent is served, after they decided to opt in to a CCB claim, the active phase of the proceeding begins. The claimant will pay that additional $60, and the respondent will have the opportunity to respond, to give their side of the story, to list any defenses they may have. Devlin mentioned that he expects to see a lot of fair use cases. So if you are a copyright user and you believe that your use of a copyrighted work is fair use, that's where you're going to start to bring all of these things up. And the great thing about the CCB, as Michael, Devlin, and Terica have all mentioned, is that you don't need to be an attorney to do all of this. The response form helps you walk through these considerations. Our handbook material helps you kind of identify some of the defenses that a respondent can have. And what we really want in those claim and response forms is just people telling their side of the story, people telling the facts surrounding their dispute. You don't have to be a lawyer. You do not need to say case law. Although lawyers are free to do that, it's not going to harm or necessarily help your case if you're an individual creator going in a dispute with an attorney. The other thing to mention at this point is that the CCB is here for you. The copyright, as part of my statutory job description, to assist people in filing claims and answering questions. And honestly, it's one of my favorite parts already. So feel free to reach us. We are at asktheboard@ccb.gov. We are there. We man that email address. We will answer your questions. And as participants move through the active phase of the proceeding, as you have a claimant and a respondent both participating in the proceeding, that's when a CCB proceeding gets really customizable. Any party can request a conference with the officers to talk about issues. We have discovery that is limited. It's going to be standardized, meaning that the CCB, not individual parties, will give discovery request documents, give interrogatories, which are basically questions to the other side about the facts of the case. And that's all going to be handled by the CCB, and participants won't have to worry about drafting any of that. We're going to give all of that material to you. After the discovery window has closed, there's another conference to talk about if there was any issues, if anybody has any concerns or questions. That's another opportunity to meet with the officers to talk about the case. Then we give people a chance to draft written testimony, and written testimony, again, is that narrative. It's restating your side of the case. Once that's submitted, the officers will make a determination, which will be public and available on our website, on ECCB, which you can access via our website, ccb.gov. And that's how a CCB proceeding kind of will flow.
Yeah, that's great. Thanks for the explanation. So I went to the ccb.gov website. I've been there quite a few times, and it's really well done. I'm so impressed that between December 2020 and June 16th of this year, that you guys like promulgated all of these rules. And I don't think people have any idea of how much work that is. I mean, I barely have an idea, and I know you know, but Terica and Mike know. But I mean, I follow these things, and I'm just like, wow, they are really going at it. And I'm really impressed that you got it done and did it so well. And I'm really excited to see what's going to happen. And so it's a couple follow-up questions, if you don't mind. So it's interesting about registration, because in the federal district courts, your work has to be registered. And we found out from the Supreme Court a couple of years ago that doesn't mean you applied to register for your work. That means that the Copyright Office either granted your registration or denied your registration, but the Copyright Office acted on your thing. And so you're saying that, how does it work again? So even if I only have to have applied for a registration, and then I can bring a claim?
That's correct. So you mentioned the Fourth Estate case, which basically says in federal court, you have to either have a registration or refusal from the office, compared to CCB, where you can file your claim with a SR number. It's called a service request number. That's the kind of the confirmation number you get when you apply for registration. You can file your CCB claim with an SR number, and there will be a couple of specific points in a proceeding where you can request expedited registration from the CCB. So you'll pay an additional $50 fee, and we'll talk to our colleagues in registration and say, hey, there's a CCB proceeding. Can you guys expedite this registration? I will say, as a former registration examiner, that the registration is moving extremely quickly these days. We don't, and I would encourage all of the potential claimants to look on our web at the copyright.gov website to make sure that to check processing times to see if that's a decision that they want to make. But after, there's an ability to expedite that registration. But there's an important distinction to be made here, that in federal court, you can go with that registration or refusal. Here at the CCB, you can come to us with a service request number, but if your application ultimately gets refused by the office, you'll have to go through that formal appeals procedure or go to federal court to continue your dispute.
Gotcha. Well, and it seems, I don't know the number, but I have to think it's in the high 90% of registrations that get accepted, that get granted, right? This isn't patent law where it's a back and forth for 3 years with the patent office on every single claim, and so yeah, most works do get registered, and so it's mostly a ministerial act, I believe, just checking that it's the proper subject matter and whatnot. And so yeah, no, that's really interesting, and I'm a copyright geek, and so I was wondering, could you just talk briefly, just because you said like the claimants don't have to cite case law, which is kind of crazy. Like, that's kind of crazy to me. Like, what else would I'm just going to say, hey, I don't think it's fair use, and the other guy's going to say, I think it is, and then what are you and the claims officers, what do you do there? I mean, and which law do you apply? Because maybe most people watching this don't know, but copyright law is not the same across the nation, right? Different circuits have different interpretations.
Different circuits have different rules. And so one of the interesting things about the CCB is we're going to play by the rules of the federal district court in which the case would have been brought. So if, sorry, Terica, you have infringed my work now. If Terica and I are in a CCB dispute, we're both here in the district, so we would have probably gone to the district court for the District of Columbia. So that's the circuit that we would apply in a case where Terica and I are in a dispute. That's one interesting point. I will say that that's kind of the, to your other point, that's one of the advantages of having copyright experts in the CCB, is that we worry about all of the circuit splits. We worry about all of the rules of engagement so that claimants don't have to. We're available to, we cannot give legal advice, but we can give all of the legal information. It's my statutory job description to give claimants and respondents all of the legal information necessary to make sure that they're can file and respond to claims. That's great. And I'm sure I'll say it again. I think the question that's going to come up the most is fair use. Like, I think people are going to have a lot of maybe misconceptions about fair use and a lot of just questions. And it's going to be interesting to see. And so last thing, I'm going to put you on the spot. I've looked online and I was kind of surprised, but you can see these dockets online. And in fact, there's several claims have been filed already. Are those dockets going to, like, is everything going to be available on those dockets, everything that people submit in writing? Yeah, so you can go on ECCB and follow the docket of a claim. We want to make sure that we're making sure that the public can kind of follow along and see how the CCB reached a determination. I can't say that everything will be available online. If something's filed under seal, if something has certain privacy requirements, we're going to take that as it comes. That's one of the interesting things about being a new forum, is we're still figuring out, we don't know what we don't know. So, but yeah, the public will have what they need to see how the CCB reached a determination. I can say that for sure. Well, I'll be there clicking on those dockets, don't worry. I will plug one more piece of information, which is ccb.gov. You mentioned we're continuing to put resources up, keep refreshing the handbook, keep refreshing ccb.gov. More resources, more information is coming down the line. So continue to, keep your eye on those resources. You can also on ccb.gov sign up for our newsnet to get CCB related alerts to your inbox. Awesome. Well, so we're running out of time here, folks, and I just want to say I really appreciate all three of you coming here to talk about the CCB. I know that each one of you has worked on it individually and put in a lot of effort behind the scenes. And so it's great to get you all together. And it's great that this thing has finally launched. If people are actually using it, I'm still pinching myself. I can't believe that this is real. And so before we sign off, I just want to go around and if anybody has any final thoughts that they'd like to say, what are your final thoughts about the CCB and hopefully something cheerful. And so, Mike, can we start with you?
I'm sort of curious, because of my own interest and background in clinical education, to see how the pro bono and the law clinic works out. Terica and I have talked about this many times, and it's going to be interesting. I know several of these law schools around the country participate in the PTO program, the patent program for law students. And it's going to be interesting to see how this develops in this area. So that's one thing I sort of look at, very carefully. I just want to mention that.
It's a great opportunity if you're a law student. I wish, like, when I was in law school, I could have represented somebody at the CCB. It would be amazing.
It is. It's something that, my colleagues at ASMP have been following, very interested in. But there are so many other issues, and we don't have time for them. But that's what I want to put a little pitch in for, because we're hoping that we see a development of alternatives to pro se for people who could benefit but lack the resources.
Yeah, great. Terica?
Yeah, so I actually have two relatively quick comments that I'll close out with. The first is to echo both Devlin and Mike in commending the Copyright Office and Maya for the tremendous amount of work that they've done over the last year and a half to get everything implemented and get the CCB up and running. I mean, I know it's been a lot of work, a short amount of time. And so just want to commend them for the hard work that they've done, including some of the resources that Maya touched on. And then I'll take this opportunity to actually plug the Copyright Alliance's resources as well. So while the CASE Act was moving through Congress, our role was to help advocate for the CASE Act. And now that it's passed and the CCB is up and running, our role now is to help educate creators and get them prepared for bringing their cases before the CCB. And so we have a number of educational resources that are either already available or that we're working on right now. So we have some FAQs up on our website, which is copyrightalliance.org. We are also working on some videos with Q&As about topics related to the CCB. The Copyright Office has its handbook, and we also have a guide to navigating the Copyright Claims Board. We released a version of it that was based entirely at the time on what was explained and explicitly stated in the CASE Act. And now that the Copyright Office has promulgated all of their regulations and kind of filled in those gaps, we are working on an updated version that's going to be available to members of the Copyright Alliance. And additionally, I just want to touch on a program that we're kind of still figuring out the details of, but we're working on a program that would help reimburse creators who bring a claim. And I think Maya touched on the filing fee. There's like a $40 upfront filing fee before the respondent gets a chance to decide whether or not they want to participate. And so we're working on a program that would reimburse funds potentially to claimants who bring a claim, but the respondent ultimately opts out. So be on the lookout for more information about that. And I'm really excited that the CCB is a real thing now and that it's going to be able to help a lot of creators.
Great. Thanks, Terica. And Maya, we're going to give you the last word.
Okay, great. I get to bring it on home. So, just on behalf of the office, we're really excited to see this vision become a reality. And we're excited to introduce more users to the system and the resources that we have set up. We hope that this can be a useful alternative to federal court for both claimants and respondents. And we hope that users really feel comfortable that they can navigate this by themselves, with a law student, or ultimately with an attorney. And just say that, this is one of our key pillars of our Copyright for All plan, strategic plan, and just, trying to help close this access to justice issue for copyright owners and copyright users.
Wonderful, wonderful. Well, thanks again to the three of you for being here today, and thanks for everybody who tuned in to watch this broadcast. And with that, I'll say goodbye.